So, good afternoon, everybody. I'm Giacinto Della Cananea from the steering committee of TARN, and I have the pleasure of being the chair for this afternoon session on EU agencies and transparency. It is a widely debated topic. Already yesterday, precisely in this room, we had a discussion of some papers presented by younger researchers, and this afternoon we have the pleasure of discussing three papers. The first one, which will be presented by Dominic, is about comparing transparency policies at EFSA and EMA. The second, which will be presented, his co-writer is overseas at the moment. Also, the second paper will be presented by only one of the authors, Emilia Corchea-Aho of Helsinki, and that is a paper about who owns the information in EU agencies. Then there's also a third paper, which is presented by YB Duma on enhancing trust in EU agencies. This being the panel, the organization that we have is based on a division of time, in the sense that after the three presentations there will be a quick coffee break, maybe 30 minutes is a long time, and then we will have the first remarks made by the two discussants, Gabi and Atul, and then the open discussion. I would like to leave enough time for the open discussion, so I will ask both the presenters and the discussants to keep the time limits as much as possible. This being our program, I'm glad to give the floor to Dominic for the first presentation. Dominic, you have the floor for the next 15 minutes or so.
Okay, thank you very much, and thank you very much for having me here. As Giacinto said, unfortunately, Ragnar is in America talking about the implications of Brexit, so good luck to Ragnar in America. But today I'll be talking about the paper which is sent around last week, which is comparing transparency policies at EMA and EFSA, and I present this with some trepidation, knowing that colleagues from EMA and EFSA will be discussing this at the end, so good luck to my presentation. So to start off, I think I want to be quite clear as what we're not talking about. So transparency for governance is one strand of the literature which deals with policies designed to alter the behavior of regulatees, such as industry. An example might be the Environment Protection Agency's toxic release inventory. But I don't want to talk about that. What I want to talk about, which will probably interest you more, is transparency of governance policies. So these are policies designed to enable outsiders to observe what is going on inside an organization. And then in order to, I think one should be clear when we talk about transparency, because it's such an ambiguous concept, which is often defined with little rigor, to be clear about what objects of transparency we're referring to. And here I refer to three in particular, which are the inputs into decision making, the actual process itself, as well as the outputs. So if we look at the two agencies, which in this room, I think we're all very familiar with both of these agencies, EFSA and EMA. But to talk about what their inputs are, so for EFSA, that's risk assessment data. For EMA, that's clinical trial reports and adverse event data. In terms of processes, we have the committees in both. And then outputs, which are scientific assessments at EFSA or opinions on medicines and benefit risk data. So this is going to be quite a quick tour of the history of transparency at the two agencies, because I would like to focus on the end slides in particular, so on the more recent developments. But just to say, first of all, that EFSA was established in 2002 after a number of trust-eroding scandals, including the BSE crisis, but also the 1999 Belgium dioxin crisis. And on the right here, you can see UK MP John Gummer with his daughter Cordelia, which is now a very famous photo of him asking his daughter to eat a BSE burger. What I find amazing about this picture is you see how large the bite is from her burger, which if you look back at the record, she actually didn't take a bite at all, and it was reported to the media incorrectly. But that's just a little tidbit from the past. The main point here in terms of transparency is that EFSA was created as a way of enhancing transparency. It was seen as an institution to bring, at the time, the disconnected areas of food safety in the European Union, which was done on an ad hoc basis together. But EFSA was dealt a number of challenges when it was made, and as was mentioned earlier this morning, in comparison to the Food and Drug Administration, EFSA had few in-house experts, had to rely on independent scientific panels, experts that wrote opinions themselves, and had to deal with a number of controversies early on. Therefore, transparency was key to the foundations of EFSA. In contrast, EMA was created after the failure of the member state system, but in particular about Commission concerns that EMA and pharmaceuticals in particular, wouldn't make the 1992 single market deadline. So EMA wasn't created for the purpose of transparency. However, with that said, EMA had similar issues to EFSA, or similar challenges to EFSA, including that its funding was be from licensing fees as well as the Commission, but predominantly from licensing fees. They would have no in-house expertise. Experts would have links with industry. That's because of naturally, in the pharmaceutical environment, expertise is linked to understanding clinical trials, which you necessarily have links. And then outsiders will rely on expert judgments. And the committee is also made up of national competent authorities, which meant that it's not just industry we're talking about when we talk about transparency, independence, but also member states. So the early policies, what I think to note here is more what policies weren't introduced, as well as what was introduced. So first of all, with EMA, actually in the mid-1990s, setting up a web page was seen as a major transparency policy, as early on as that. So times have obviously changed a lot since then. But the things to notice is that both EFSA and EMA didn't have any transparency policies that referred to the data that underpins decision-making, and EMA didn't have any in relation to operational transparency. So, for example, the actual discussions amongst committee members. So how were the agency reviewed up to 2005? Well, EFSA was attacked early on, and in particular by the Austrians on genetic modified organisms. Some said they couldn't view conflicts of interest. However, EFSA was viewed positively, with high quality opinions over handling conflicts of interest well, and in particular they were congratulated on how they dealt with acrylamide and semicarbazides. EMA, the executive director at the time, Ferdinand Sauer, said that transparency inevitably led to greater scrutiny. And we can see this from ISDB, which is the International Society of Drug Bulletins, criticizing EMA's EPARs, as well as academics such as Abraham and Lewis, as well as Silvio Garatini, who was an ex-member of the CHMP, which is the Human Medicines Committee. But transparency was also welcomed by the agency as well, by a number of groups, including patients, doctors, and others. So if you look here, for example, Alistair Kent says that those setting up the agency were sensitive to patients' refusal to be patronised and brave enough to see this as an opportunity for the new institution to commit itself to openness and transparency. Trust in the regulatory system and confidence that medicines are safe and effective can only benefit from this. So what happened in the next stage? How am I doing for time?
Yeah, go ahead.
Good. In the next stage, EFSA came under a lot of criticism, especially on genetically modified organisms. So EFSA continually said, based on 80 studies or over 80 studies, that GMOs were safe. However, member states continue to oppose GMOs' EFSA's risk assessment. But what was happening was member states were de facto ignoring EFSA's advice, even though there was overwhelming evidence. So the reaction was to introduce more process transparency. And again, here I think it's important to be clear about that being process. But But what happened with EMA was the transparency train slowed in a way, and this was due to a number of other commitments that the agency had to deal with, including the new pharmaceutical legislation in 2004, the enlargement of the EU, wider responsibilities, in particular to do with pharmacovigilance, the bird flu and swine flu, as well as issues to do with commercial confidentiality, which I know some of the other speakers will be talking about in terms of transparency. However, by 2009, EMA had become more strategic and delivered its 2009 draft policy. So what happened since then? And I would define this for both EFSA and EMA as a sort of new transparency era. One of the big scandals that affected EFSA was Diana Banatai's resignation scandal. So Diana was sat on one of EFSA's was a chair of one of EFSA's committees. They then found a link between the International Life Sciences Institute, which is an industry body, and EFSA asked her to resign. She then stepped down from ISIL, sorry, I didn't get it right. She then stepped down. And to continue her job, only for 2 years later to resign EFSA and then go on the board, become the European director of the same body. So obviously this was a significant issue for EFSA and had a lot of criticisms of conflicts of interest. The European Parliament Budget Committee said that their policies were insufficiently rigorous and detailed, and the Commission's had concern over a loss of trust in agency decision-making. EFSA was also increasingly attacked, especially with more data being available from NGOs, including the Corporate European Observatory on multiple times. And what this led was, in a similar way to EMA, as I was saying in a second, was this led to a renewed focus on input policies. So this is looking at the data and information that underpins decision-making, rather than the process itself or an explanation of the actual outputs of decision-making. So EFSA went on to have its new document, which was Transformation to an Open EFSA, as also its new warehouse project. As Bernard Uhl, the executive director, said, our scientific data and warehouse project, which will develop over the next 3 to 4 years, will open as much as possible our treasure trove of data to be reused by others. So what happened with EMA was at a similar time in 2010, EMA came, there was 2 events with the European Ombudsman, which again I think some of the other panelists will be talking about, where EMA refused to give access to the data that underpins decision-making in 2 cases. However, in 2010, the Ombudsman disagreed with the European Medicines Agency. I must say they said due to commercial confidentiality reasons, that's why they couldn't disagree with the agency and said they should release the data. At the same time, Thomas Lundgren, who was the executive director of the European Medicines Agency, joined a pharmaceutical consultancy with criticisms that there wasn't a good enough cooling off period after he stepped down, as well as Vincent Salvatore joining a Brussels office of Sydney Austin, and that was their chief legal counsel. But also a lot more criticisms on and pressure on the European Medicines Agency from many other actors. And I can't really underemphasize how many different actors and how much interest came onto EMA. So this was from campaigners who wanted to reuse the data, such as the Cochrane collaboration, the All Trials campaign led by Ben Goldacre, journal editors from the British Medical Journal, Lancet, and many of the other big 5, the committees, as well as politicians such as Glynis Wilmot, MEP. And this is a quote from Cochrane from 2007 when they first applied to the European Ombudsman, and they said, "We believe the current lack of openness and transparency in EMA violates basic principles in the EU Treaty and must be changed, and is also unethical. It is evident that this attitude leads to suboptimal treatment of patients and sometimes even lethal harms." So you can see there's a lot of pressure put on the agency. So what was the reaction? Well, again, similar to EFSA, the action was to switch to input policies. So as Guido Rassi said, an unprecedented level of access. So they started with a new reactive access to documents policy and moved on to a more proactive one, which I know that Florence said she's going to be talking about later, so I won't talk about that too much now. But also introducing a new clinical trials register, having a new website for suspected adverse reactions, publishing committee meetings, so therefore more operational process transparency, and then also new developments about having patient involved in decision-making. And finally, on the 2nd of October, their new clinical trials reports policy. And as Guido Rassi said at the time, this unprecedented level of access to clinical reports will benefit patients, healthcare professionals, academia, and industry. And this, for me, is the crucial line that says, EMA expects the new policy to increase trust in its regulatory work as it will allow the general public to better understand the agency's decision-making. So here's a quick timeline on what I've gone through very quickly before I just have one slide on conclusions, is that in 1995, you can see on the far left, EMA was established. Later on in 2002, EFSA was established. Both were reviewed positively in an interim period. However, it all changed in 2010 when the focus became much more on the inputs into decision-making. So this led from EMA's ombudsman recommendations and at EFSA, criticisms of conflict of interest. So different ideas around transparency there, which eventually led to this. So I think one way of looking at this, before I go on to my conclusions, is the idea of fishbowl transparency. And this is something coined by Kerry Coglanese, or perhaps not coined by him, but definitely written very well about by him. And he said that, and these are a lot of the policies being put forward at the moment, that the aim is to expand the release of information, documenting how regulators come to decision. So this might be publishing meeting minutes, or indeed, in this case, the data that underpins decision-making. However, there's a different type of transparency that hasn't been focused on as much, and this demands that the regulators offer explicit explanations for their actions and decisions. This might include concise, understandable communications. I think we have to be distinct when we talk about transparency about the two. So I think everyone can agree in principle that transparency is a good idea. However, what policies we put forward, I think we should be much more careful about. So to sum up, because otherwise I'm going to get in trouble, I'll just say a quick 6 points that I take away from this, but I think there's a lot more that could be discussed in such a review. Firstly, transparency is here to stay. The train has certainly left the station, as a number of regulators have said. Of course, we need to make sure the train goes in the right direction and doesn't crash, but it's definitely here to stay. Policy designed to enhance transparency will not necessarily do so, and they can also have severe unwanted effects. I know a lot of the regulators are dealing with these effects now, or perceived effects indeed. I think regulators should clarify the variety of transparency, their varieties of transparency policies, so we're not always talking about transparency as this general thing. You know, there's a difference between input policy and then getting a video streaming a committee meeting. You know, they're completely different ideas with different consequences. I think the regulators need to become stronger dealing with the new environment, especially in the media, and I'd encourage academics like us to support the regulators in doing this. I think this is something that's really important. The regulators shouldn't be on their own. I think these sort of meetings are great for that sort of thing. And also another issue is, what are the impacts on resources? You know, the ultimate goal of a lot of these policies is to build trust or otherwise. If there are other policies that can't be implemented that would have built trust otherwise, then I think we should be looking at that as well. I will, under one note, though, is that with all that said, the solution is not to censor information after all the regulators are not perfect, as shown by BSE, Vioxx, Avandia, and others. So thank you very much for your attention.
Thanks. Thanks very much, Dominic, both for the quality of this presentation and for keeping the time that we had agreed. Now the floor goes to Emilia for her presentation on who owns the information in EU agencies, the ownership of the information, and the challenge of transparent governance. You have the floor for the usual 15 minutes.
Thanks.
Thank you.
Thank you. Thank you. So my name is Emilia Korkeaho from the University of Helsinki. My colleague Päivi Leinos-Sandberg sadly can't be here with us today. As the previous speaker said, I'm also a bit nervous for the reasons he identified, because the paper concerns what we call the emergence of ownership paradigm and the protection of commercially sensitive information in 3 EU agencies, EFSA, EMA, and ECHA, and the representatives from those agencies sit here. So, yes, I noticed that. Yeah, yeah. So, let's get started. Päivi and I submitted the abstract in the summer, and after the submission, we came aware of the pending case, and I thought it would be nice to just talk you through the case. The facts are relatively simple. So 4 members of the European Parliament made a formal access to information request to EFSA in order to gain access to studies on the basis of which EFSA concluded that glyphosate is not so prone to so it's not carcinogenic. Now, what has happened, EFSA has been more or less reluctant to grant access as they see that the public interest in disclosure does not override the commercial interest of study owners. So what EFSA did instead was that it entered negotiations with the companies. And they were trying to find an acceptable solution, acceptable meaning that's also acceptable to companies. And then as a result, EFSA offered a physical reading room for these 4 members of the parliament, so again indicating that this is a solution that both EFSA and the companies accept. Now, what happened then? The members of the parliament did not accept the solution that was offered to them, and now the case is pending, and the partial access has been promised by early December. So we don't really know yet what's going to happen. So this is the policy context where we began then a couple of weeks ago to write our paper. They are 3 major questions that we want to identify and hopefully also answer. One is that who should have the right to benefit from access under regulation, and whether the purpose for which access is granted should be taken into account. And finally, whether the use of information in public debates can be limited. So is it possible to give public access to certain documents on the condition that those who have obtained the information won't release it and don't talk about it in public? So now the legal context and the policy controversy. So as the main rule, all documents held by the EU agencies are available to the public, except information the disclosure of which might harm interests protected under EU law. Again, unless there's an overriding public interest in disclosure. So this is from the regulation 1049/2001. This is the main rule. So of course there are then some specific rules in the founding regulations of these agencies, but it seems to us that the relationship between the regulation 1049 and the specific agency rules is a bit unclear. And also it seems that there are further problems created by relatively complex implementing rules. We have spent considerable amount of time going through the websites of these 3 agencies, and although I know that they are representatives from those agencies here, I still say that I found them really, really complex, and I'm not sure. I mean, I'm a lawyer, and I'm really trying to understand what is applicable and what's not, and I think it was quite hard. I'm sorry about this. So, but just the situation is that the scope of protection of commercial interests in EU agency institutional practice has become highly contested. So this is a very hot topic, as the case I introduced in the beginning shows. So in our view, the particular concern now relates to the role of companies in agency decision making. As you may know, that the regulation says that third parties must be consulted, unless it is clear that there's no need to give public access. But in our view, it seems that the companies have a stronger role in agency decision making, and it might just lead to a clash with the certain criteria identified by the Court of Justice, and these criteria they require that the responsibility for assessing the existence of the commercial interest protection and taking the decision on the disclosure of the information is with the agency. And it is the agency that needs to ensure that the exception invoked by a third party is indeed applicable, provide reasons for its decisions, and when necessary, defend its decision in court. Now we went through some EU ombudsman decisions and also some case law of the European Court of Justice. As it was sort of mentioned, and I think it will be discussed in the presentation after ours, that there's several or some decision concern, especially EMA and public access to studies and information that EMA has. However, the case law is a bit more limited because not all, but some cases are actually settled out of court, especially the case you mentioned concerning UPV and EMA was sadly decided sort of out of court, so we never, sadly, but we never knew what the court would have said about this. Then we actually found several decisions of the General Court on the need to grant interim measures for preventing disclosure while the case is still pending. And in two quite recent decisions, these are from June this year, EMA was actually ordered not to disclose information. So EMA was willing to disclose information, but the General Court said that do not. The interesting thing about these two cases was that there were competitor companies seeking access to documents seemingly for commercial purposes. And of course, the question that then raises that whether it is the abuse of public access rules. The order, sort of, the court recognized that there is that problem that it's not necessarily stakeholders or civil society, so it's other actors in the market wanting to get access to the information. Now, this is perhaps the most problematic part of our presentation because we are not really we're not experts on intellectual property rights, but it seems that the information now that companies provide to EU agencies in the context of different regulatory procedures is a third-party property. Then that triggers the question of copyright protection. So are these rules relevant? This is the question we then sort of ask. And if they are, how should they be balanced against the principles of openness and transparency? What about public interest? So how do we then define public interest? So there's Article 16 in the regulation, and it mentions that copyright rules. And now, of course, the relevant question is that whether that article can prevent applicants from releasing or using information they have obtained under public access rules. For example, the members of the parliament in the case I presented in my first slide, that are they then is the information given to them on the condition that they don't talk about it publicly and they don't release it further on the web. However, we see that only commercial use is prohibited on the basis of Article 16, so information can be placed on the web or its content can be used in a public debate without any restrictions. Now, preliminary findings, and then I have one more slide, just future questions, so I think I should be on
5 minutes.
Okay, perfect. So First is that there seems to be what we have called shared ownership, that the companies have come to assume that they can sort of exercise a veto over how agencies apply these public access rules. They say that it's our information, and when you consult so we can sort of influence the agency's decision making. And to us, it seems that this third-party consultation required by the regulation has become more like a negotiation rather than consultation, so that the agency and the companies, they negotiate on how those rules on public access should be applied. More generally, we think that the operation of public access rules in agencies has a very high public interest dimension, but it, however, still remains understudied. There's also little jurisprudence, also because many of the cases are settled out of court. But there's also so limited legislative guidance for settling the balance of what should be done. So we identify then two main questions for future research. Do EU agencies have the competence and even legitimacy to make decisions in the public interest? Because, yeah, in these cases, they need to decide whether there's a perhaps, or often they are interests that are commercially sensitive, they need to be protected. But there is the requirement that this data must be published if there is a overriding public interest, and can agencies make that decision? So what is the meaning of public interest here? Then are accountability arrangements sufficient? And then we also ask whether we should have the EU legislature to step in and just give a bit more guidance on how that balance between transparency and confidentiality should be settled. And finally, what is the function of public access rules? Should the widest possible public access be provided to all, from members of the parliament to the competitor companies? Because in this paper we referred to it was one of the interim measures cases where I think it was EMA who argued that the widest public access should be provided not only to patients and doctors and researchers, but also to other actors in the market. And we're not sure whether that's actually at least it's not the primary function of public access rules. Thank you.
Thank you so much. Thank you very much, Emilia. This was again a very interesting presentation, and thanks also for keeping almost rigidly the time limits. So we now have the third presentation, which is by YB on enhancing trust in EU agencies through transparency and independence. Recent developments in EU case law regarding potential risks to public health and the environment. Please.
Thank you, Mr. Chairman. I always think it sounds very philosophical if my first name is pronounced the way you do it, YB. It's got to be more factual, this introduction. And I'll start by picking up on something that Michelle said. She referred to the fact that we don't trust our administrations anymore, and our agencies, I can add. And she was wondering if I understood her correctly, if constitutionalization and more transparency alone would solve these issues. In my paper, which I submitted far too late, I'm so sorry to the person who is going to react. I actually quoted Frans Timmermans, who a couple of days ago said that there might be a need for a new social contract with EU citizens and the EU institutions and agencies. If not, he said, I have a real fear that the European project might come to a halt. He foresees that there are big challenges ahead. Now, of course, when we talk about transparency and increased transparency. With a legal background, all I can say, let's say from a layman perspective, is that I study all these cases and I write annotations, and then I have to reread them because I actually forgot what all these annotations were saying. But I get the feeling that the agencies and institutions do not fully comprehend the eagerness with which many members of the public NGOs are looking for more information, and the immense distrust indeed that there is against all these institutions, and Brexit is just one event, but there's the call for a Frexit, there's the call for a Nexit in the Netherlands. Populists are winning ground in the European Union member states as well. And I feel that although of course I cannot prove anything, that if you enhance transparency, at least you contribute a little bit, or the other way around, if you do not provide access to information, you are just helping populists. So I think that's a worthy cause to talk about the boundaries. And of course, being a lawyer, I look at what the court says about these things and where the boundaries are of the exceptions that are being invoked. I say frequently, because that's the cases that I see time and time again, where the Commission or where EFSA, notably, is invoking these exceptions to say, yes, the openness, transparency, but in this case, commercial interest, data protection, the ongoing negotiations. So, against that background, I looked at recent case law of both the General Court and the Court of Justice. From the angle, how does the case law contribute to enhancing trust in these institutions and allowing for exceptions to be invoked only when that is really necessary. One of the first cases I examined in the paper, which now, thanks to Agnieszka, has been uploaded, is a case where two NGOs, Client Earth and Pan Europe, went to court against EFSA. And the reason they did so was that they weren't granted access to all the information that they had asked EFSA about what individual experts in working groups had said in advising EFSA on setting up new guidelines regarding the interpretation of plant protection regulation. So these guidelines had been presented to the expert as drafts, and then the expert had made comments, and then the draft guidelines had been changed. Then they had been put to a public consultation, and the two NGOs wanted to know what changed and what these individual experts had said, what comments they had made, because Pan Europe, one of the two NGOs, had found out that in at least one of these working groups, 8 out of 13 of the experts consulted and paid for by EFSA had ties to industry lobby groups. So they said, we want to know who said what, and in that way, probably reconstruct, but maybe the EFSA representative can say more about that. Reconstruct what...
I'm not representing.
No, sorry.
Just to make it clear again.
Can say something about this. They wanted to know who said what. And then the argument first they... long story short, in the end, they got the NGOs got the comments, but they were anonymized. They couldn't see who made which comment. On the other hand, at the same time, the names of all these experts were available on the website of EFSA. So we knew the names, we knew the comments, but not who made what comment. And that was what the NGOs insisted on knowing. And the General Court, when it came to that, said that this is personal data, so this interlinkage, personal data under Regulation 45/2001 on protection of individuals regarding processing personal data. So it is in principle not to be submitted unless you show that there is a necessity, and you didn't do that, so you are not entitled to it. They appealed. The Court of Justice said, well, it is indeed personal data, and in my paper I make a few comments on the question whether that is a wholly justifiable. Of course, it's the law, but one can criticize that. Anyway, they said it is personal data, indeed, under that regulation, but the General Court was wrong to say that no necessity was established by the NGOs. They said the NGOs had to show that there was a necessity on the one hand, and had to also, and if they did so, then it was up to the EFSA in this case to explain that there was a reason to assume that transfer of the data might prejudice legitimate interests of the data concerned. And the NGO did demonstrate, according to the court, the necessity, but the EFSA didn't show the evidence they should have shown a specific and actual adverse effect on the protected interests if they want to use the exception. So they had to, and they didn't do that, they didn't demonstrate this concrete risk. So that was a narrow interpretation of the exception, adding to increased transparency. A second case that I looked at concerned another hot potato, endocrine disrupting chemicals, so hormone disrupting chemicals. There's been interesting cases, Sweden versus the Commission, but in this case, and in this case actually the cases I have looked at, didn't write out the number, but as far as I remember, Sweden supported the NGO in question, who challenged the fact that it didn't get all the information it wanted about EDCs, endocrine disrupting chemicals. They got a lot, but not everything that they wanted. So they complained about that. And they said that they were entitled to get this information under the Aarhus Regulation 1367/2006 on access to information regarding the environment. The General Court dismissed these arguments, but where it came to the other arguments they had put forward under the Public Access to Documents Regulation, it did find that under Article 4.3 of that particular regulation, a justification, the justification by the European Commission wasn't sufficient because it didn't provide precise and specific info on how these, how providing the information would disrupt the decision-making processes. So again, an exception being invoked, being interpreted in a narrow way, and helping in that way the NGOs, putting the onus of proof, you could say, in the court of the European Commission. Now, this is a decision by the General Court's third chamber. And interestingly enough, I found out that actually there's another decision by the second chamber in another case of the General Court, and that's a case Client Earth versus the Commission, where it seems that there is a difference between the opinions of these two chambers, because the second chamber actually said that in similar cases you don't need to provide a concrete evidence to demonstrate that the threat to the decision-making processes exist. Instead, the second chamber said a tangible element suffices, a reason which shows a reasonable, foreseeable, and as long as you ensure that it's not merely purely hypothetical, that there is a negative influence on decision-making, then that already suffices. So I'd say that there seems to be a difference between these two verdicts. Appeals have been lodged, and again, from the point of view of increased transparency and the needs for that, I hope that the court will follow the reasoning of the third chamber, as you might understand. As for the arguments regarding the Aarhus regulation, An issue there, of course, is when can you talk about information relating to the protection of the environment? That's, of course, a specific issue, but occurring time and time again. And the point is that in the Irish regulation, it says that it has to be about emissions to the environment. And then if you talk about substances, the question is, when can we talk about emissions to the environment? The European Commission said, well, this is a substance, and so it's not about information on emissions to the environment. The issue was not dealt further with by the General Court, but it has been picked up for the appeal by Advocate General Cocotte, who said that it is indeed a substance, or if it's about glyphosate, sorry, I can't think of the exact name anymore, but it's to be used in pesticides. Pesticides are to be used in practice, so they will end up in the environment. And so her advice is that we should regard this as something that is linked to an emission into the environment, and thus the information should be given in principle under the Irish regulation. And she also explained that it is not merely hypothetical emissions, as the Commission had put forward. She said it's generally, if you authorize a plant protection product, then that product is generally released into the environment. So it's not hypothetical, and therefore there's a sufficient link. And then I'm skipping something because I tried to stick with my time. I forgot to mention that I was talking about glyphosate case. I mentioned the word already. Glyphosate, of course, is very contentious. In my paper, I talked a little bit about a workshop that took place in May this year at European Parliament, where EFSA, European Commission, and parliamentarians, obviously, and NGOs were talking about whether or not it is a potential risk in this particular active substance, that was the word I was looking for, or not. And there's a transcript of the whole session, which I link to in my paper, where I found out, and you can find out, that actually the Commission representative said, we have looked at it carefully, and we came to the conclusion that, in spite of the fact that other WHO agencies said that there is that the substance is probably carcinogenic for humans, we think that there is sufficient reasons to say that there is no uncertainties, and so there is no need to apply the precautionary approach, which I found a very interesting way of reasoning. Anyway, more on that in the paper. I'll round up by saying that the Advocate General on this glyphosate case, besides the remarks on the Irish Convention, also said that the case should be sent back to the General Court. But if the court would decide, she also remarked that the request for information was about 20-year-old information, and that even if you would publish that now, in these 20 years, the information in question is not really going to change anything, and not going to make producers who might have had interest in the information on how to make the substance 20 years ago. By now, she said that's it's all probably they figured it out themselves. So you should allow access to this kind of information. This particular case will be decided on the 23rd of November already. So this year we will find out whether the court will continue its narrow approach versus the exceptions to access to information, or whether it will be convinced that, for instance, the second chamber of the General Court was right in saying that you can't expect Commission or agencies to justify in detail each and every invoking of an exception. As might be clear from what I told you, I hope that they will follow the narrow approach in this respect and add to transparency in that way. Thank you for your attention.